beloved audience, good evening and welcome to the Regnum Continuous Legal Education brought to you live by Starcross Television. I'm delighted to bring you once again to this interesting program that has to do with those that are well equipped when it has to do with legal matters. All those are legal practitioners. This is your program. It is time for you to join us, and for those of you that are having issues at all, cases that you can't resolve, this program has brought you the solution you need. My name is Joy Dambo, and I'm so happy that you're joining us this evening. Today, of course, we'll be taking the conclusive part of the topic that we have been treating for 2 weeks now. And it might interest you to know that if we don't conclude, we will not end. So today we are taking the conclusive part of the applicability of the rules of natural justice in the judicial process. It is a conclusion today, so sit tight. We're not even going to waste much of your time because we're just going to hit the nail there on the head. Okay, so of course, to do justice to this topic, the conclusive part of it are the ever-ready lawyers, the barristers that are here seated to do justice to the topic. And I'm starting here, of course, with the senior man sitting right beside me at my immediate left. He is Christ Ambassador Barrister. Forgive me because he will always start with Christ Ambassador. That's the title the Father has given to us in this kingdom. But I don't know, lawyers usually prefer, they're always modest if they want us to call them brother or...
No, you're right.
I'll give you all the, yes, I'll give you all the titles. Christ Ambassador Barrister Kenneth Anthony Ituro Abase. You're welcome, sir.
Good evening.
Good evening. How are you?
I'm okay.
Yeah,
happy to be here.
Yes, you're smiling today.
Yes.
It seems there is something that you need to share with us.
Yes, of
maybe
course.
yeah, in the process we'll get to know that. Yes, sitting next to him is Christ Ambassador Barrister Roland Osim. Welcome, sir.
Thank you so much.
Good
It's okay,
evening.
Father. Thank you.
How is your health today?
I'm fine.
Very fine. It's obvious.
Yes. All
Okay.
glory goes to the Father.
Yes, so thank you so much for joining. Beloved audience, you can as well share the link, tell a friend to tell a friend that Starcross TV is live and we are here to discuss legal matters. And today is a conclusive part, like I stated earlier. So sit tight and watch. Don't change that channel, okay? So let's go without wasting much time. Let's just go straight into the to whatever that was discussed. To tell you that I'm a good student, I learned. We talked about natural justice and the meaning for you to just give. It simply means giving fair hearing to whoever is involved or the victim or whoever is coming to court. Just pay attention to whoever wants to say anything. Fair hearing should be given to both parties. Simply summary, if I'm correct.
Yeah, you're right.
Thank you very much. I like that credit. So now let's go straight. I would like to ask, what is the remedy for the breach of natural justice? I think since we're talking about natural justice, it's time for us to talk about the remedy.
Yes.
So what is the remedy for the breach of natural justice?
Yes, thank you very much, moderator. There are a lot of remedies that are available to a person whose to which natural justice, or a person who is supposed to have had a right of natural justice being meted out to him, and then there is a breach. One of those remedies is that if it is in a case, if it was in a court case that it happened, then that entire legal process can be nullified. That is the first remedy, as in the entire trial could be nullified. And a good example is when there was a case of the State versus Clement Song in 1975.
Okay.
In our law report, we say 1975, 1 Supreme Court, 1, page 1.
Of course.
What happened in that case is that the man was arrested with firearms. That is the late governor of this state. Clement Song was a governor of Cross River State then. So he was arrested with firearms and he was charged to court. Charges were drafted. And then at the end of the day, that charge could not be sustained.
Okay. Reasons?
The reason being that it was wrongly drafted. And so that charge was struck out.
Now,
And
when you say
when-
wrongly drafted, how was it wrongly
that is for the
drafted?
draftsman.
Oh.
Because if somebody is being charged to court, then we will normally say that you, let me not mention your name, but if I want to mention it, with that you, Joy Dambo, at so place on so they did
This
commit so
particular-
offense which
yeah.
is punishable, which you did commit this offense under this section and which is punishable under, do you plead guilty or not
Or not
guilty?
guilty.
And then you say not guilty, and then the trial begins.
So in this
So
case,
in
was
the
he
process,
guilty? Okay.
he was guilty. He was seen with the firearm quite well.
Okay.
But in the process of drafting the charge, there was a mistake, and then the law of natural justice had to play,
Okay.
because they say that you cannot what we call double jeopardy, that you cannot charge a person twice for the same offense. So that played in his favor.
Wow.
After the first charge was drafted, then they tried to file another charge, and
This could
the,
not
the,
hold.
the lawyer that was defending him now said that this was a second trial, that the first trial was struck out. And then, seeing that you cannot try a person twice for the same offense is a rule of natural justice.
Wow.
So that was struck out. So first is that the entire legal process, procedure can be nullified. Secondly is that there can be award of damages,
Okay.
payment of compensation,
Okay.
yes, to the person that has been breached.
So who about the person that wrongly wrote these allegations, or whoever was in charge of the reports?
Yes.
Yeah, what happens to the person?
That is what we are saying, that when the court is awarding the damages, they take
Okay.
into consideration that person. So
Or
if
the
it
person
is
that
me,
will have to pay.
yeah, so if it is me that maybe libeled you,
Mm.
and then in the process, and then as we were doing the matter, we now realize that your rules to natural justice were also breached in the process, and the court wants to award damages. It is against the person, you understand. For instance, like if like that case I just mentioned now,
Yes.
if the person is being charged, after he has been discharged and acquitted, he now has a right of action against the state and the person that reported. If there is if it's a criminal case, it is against the state. So we are all witnesses. You go there as a witness, I go as a witness. It is the state that the crime is committed against. So when he comes back, he can file a suit against for damages against the state and the person that was a witness. And so that's another. Then they can be made to tender apology.
Okay.
An apology can be tendered to the person. Lastly, the person can go on appeal and upturn the decision, that earlier decision of the court, in case there was a decision that was reached, that is, a judgment was delivered. He can as well take the matter up to the court of appeal and ensure that that judgment is upturned.
Okay.
He can go to the Supreme Court and ensure that that judgment is upturned.
Okay.
Yes, but in strict legal parlance, we normally say that when there is a breach of the rules of natural justice, that court did not have jurisdiction to even try the matter. That the court will not have jurisdiction, because the rules are that there must be no feature in the case that robs the court of jurisdiction, and breach of natural justice is one of the features we are talking about that will rob that court of jurisdiction. So which means that case is ab initio, that case ab initio, the court did not have jurisdiction to entertain it. So the matter could be taken upstairs to the Court of Appeal or Supreme Court, and then it will be upturned.
Okay.
Let me give my
Yes,
the
yes.
opportunity
Very
to also say
self-same, sir.
something.
Yeah, concerning the remedies, he has already listed them. Nullification is one, damages is one, compensation is one. But when you are looking at damages and compensation, you equally look at the kind of offense or the breach. Because like when you talk of compensation, that is when you cannot to say, let me give damages for this thing to now sustain this. So you now go into compensation. Now, when we were talking about from the beginning of our discussion on this topic, we omitted one important issue, which is the lynching of Deborah Yakubu. Yes, she was killed with the allegation that she blasphemed.
Yes, blasphemed.
Now, if she actually did that, she was not given fair hearing.
She wasn't, of
yes,
course.
because by right, she would have been arraigned somewhere or called to a certain panel for them to equally ask her and listen to her own side of the story.
Very correct.
So, but they did not. All what they did was to say she has blasphemed, she has did this and that, and finally
tortured
she
her,
was
tortured, no trial,
killed,
and burned to death.
That is breach of natural justice, which we are talking about.
Of course.
So that is just what I wanted to bring up today, to this our topic for today.
Yes, Barrister Kenneth made mention of something while he was talking, so I just had to hold my peace and allow him to land. Yeah, he said something about if the offender is being charged twice for the same offense due to mistake or errors in whatever report that was compiled, and then at the end of the day, if the lawyer of this same person stand up to say this person has been charged twice for this particular case, and because of that they discharge the case, and the first time he was actually guilty, this person was actually guilty of this crime, but because there was an error, and then the error
call it technicality.
Okay,
there was a breach of technicality.
Yes. And then this person was actually guilty of this crime. So because of that little error, you would say this person should go without being punished.
But that is the law of the land.
And even if the person is found guilty.
Yes, it has happened several times where a person is guilty, but due to technicality, when you do not follow the rules, like now these rules of natural justice, when you do not follow it, when there is a breach occurs and it inures to the individual, the person is presumed innocent until found guilty.
Yes,
under section 36 subsection 5 of the 1999 constitution, our own Nigerian constitution, any person that is approaching the court is, even if they catch him with the gun, like I said, he is with the gun, we are seeing the gun, he is still presumed innocent until proven guilty. And then by the time you do not abide by the technicalities
as to prove
beyond reasonable doubt that the person is guilty, the law says instead of it to punish one innocent person, you allow 100 guilty people to go free. That's what the law is.
Wow.
Yes, so in that kind of situation, that like it happened in that case, I could make a good use of it as an example because it's late.
Okay.
You understand? As it happened in that case, the law leans against double jeopardy. So such that nobody that will show that he has been already taken to court or maybe even punished for an offense, that will be charged again for that same offense. So what happens is that when the technicality arises and that technicality makes that person to go free, the person is free indeed. Yes, that's what the law says. In fact, by the time when we'll be running down our section 36, you will see one of the provisions that says that you cannot charge a person twice. You are shown that he has either been convicted or pardoned for an offense. For instance, some of our governors that were pardoned last time, they can never again be charged for those offenses because they were actually convicted. And then at the end of the day, the president or the state governor has a right to pardon. Once he issues that prerogative of mercy and pardons, that is the end of it. You cannot charge them again for that offense.
So don't we consider it corruption?
It's not corruption.
It's not corruption.
Yes, because honestly, because if we, anyways,
it's not corruption.
Since that's
in fact, in some other claim, there are what we call says, except you sentence them in absentia. You sentence a convicted person in absentia. The person, you even sentence them without putting them in prison. They are convicted, but they are not in prison. You sentence them in absentia. The man has run away. They try him. he was not there to defend himself, but there are evidence to show he committed the offense, then they sentence him as absentia. So while he's there in America or in London, he is convicted in Nigeria, but the only thing is that he is not in the prison walls. You understand?
Yes.
So, but if he now is to come back into Nigeria, and then he now tells the president that, look, I will not come back into this country unless I'm pardoned. The president said, okay, I want you to come back. And he has the power of pardon, fine. Once he issues the pardon, that's the end of it. He comes back into the country, and then everything is erased completely.
Okay.
So that's the law.
Okay, thank you very much for that explanation.
Yes.
So I will now move to my next question. So, what is the importance of the rule of natural justice in a court? Yes, I would move that. The importance of the rule of natural justice in a court. Barrister Simpson.
It's okay. The importance of rules of natural justice. One of it is that it ensures equality before the law.
Okay.
The law provides that, or in our constitution, every man, everybody is equal before the eye of the law. There's no rich man, there's no poor man. So that is why when you look
in our
at
country of today,
yes, yes, it's still there. That is why when you look at the image of a law, you see that it is a woman blindfolded. That's to show that law does not see whether you are rich, you are poor, you are tall, you are short, whatsoever. You are all equal before the law. So this, when you apply,
and does not see if you commit a crime so long as you're proven not guilty.
Yes, it does not see anything until when they wait
The scale,
the law,
that
the scale. Yes, till to your end. That means you are guilty. So now, as it stands now, if you follow, or the application of this natural justice is going to one of the importance is that everybody is equal before the law. Then the second importance is that it provides quality administrative proceedings.
Okay.
By the time you follow these rules, you see that whatsoever decision you arrive at will be devoid of bias, will be devoid of any unfairness or whatever. It will give you the perfect fair hearing and what the law stands for. Yes, and it will be seen that justice has been done, not just to be had, but it has been done. So those are some of those importance we derive from the importance of these rules of natural justice.
Okay.
Yes.
So do you have anything to add to that?
Yes, I do. I have another importance of the rule of fair hearing in judicial system is that it also protects the observance of the rights of people appearing before a court or panel against arbitrariness, arbitrary practice. You remember that Montesquieu, in his book The Spirit of Law, had said that the rule of law is better than the rule of a man. So that was why they now separated governmental powers into the judicial, the executive, and then the legislature.
Okay.
And then you now find out that there is what we call executive lawlessness.
Separation of power.
Yes, there's what we call executive lawlessness. The executive, they always go to execute. Like we say, police brutality.
Yes.
So in the process of executing the laws, a lot of things happen, a lot of thoughts is committed, a lot of breach of contract. So now with the principles of fair hearing, it helps the rights of these people to be observed, and then rules out every arbitrariness of a person, such that at the end of the day you are not doing justice according to your whims and caprices. You are rather doing it according to laid down rules and procedures. And then it serves as a code of conduct to administrative panels, judicial panels of inquiry. It serves as a code of conduct because at the end of the day, by the time that person is found guilty, the first thing is, like I had already stated in our earlier in this program, the first thing, for example, if it's an administrative panel inquiry, they find out that did you query him? They said, did he reply? You understand? And then in his reply, did he admit committing this offense? You understand? And now, did you set up a panel to try him? Did he still come to that panel to confirm that he committed the offense? Or were there witnesses that came in to confirm that he committed the offense? At the end of the day, if he was in an institution, was his head of department, a member of that panel, was his friends, a member, were people that he had problems with prior to that, the commission of that, were they members of that panel? So that all this rules out that issue of bias and arbitrariness. So that is the importance of the natural justice in an adjudication.
Okay.
Yes.
So now I would like to ask, so how will you observe that a judge is being biased?
Yes. Well, let me start before handing over to my
yes,
friend.
because after all this you said, how will you be able to observe that a judge is being biased?
One of them is preconception.
Okay.
Once the person is preconceived, once the person is, for instance, if the person is a feminist, let us look at the situation where a woman comes to report that the husband is not giving her feeding money, and the judge is a woman.
Is a woman.
And the judge is a woman. You know what I'm talking about?
Yes.
A case of rape.
Oh, a case of rape. And the judge, so there's that preconception. The person, he has already made up his mind that, look, once they bring that man, I'm going to sentence him to death. Even when the law does say sentence to death, you understand? He said, I'm going to sentence him to death. Why did he rape? You know, because she is a woman. That's emotion has gone into justice delivery. Okay. You understand? Let us look at the situation. The person is already bent. Let us look at the situation where a judge is delivering judgment based on the fact that the brother is involved. Yes. Bigotry. You understand? There are a lot of, by the time you look at it, the definition involved bigotry, bent, prepossession, conception. It's all about you having made up your mind. You are not open to any defense from the other party. Your mind is already made up that this is the judgment before I even begin. So that is how you observe. That is how you observe that person is biased. Such that if there is a defense that comes in, you find out that the judge or the arbitrator will throw out that defense. Because why, like we already explained, she is a woman. Why will a woman be treated this way? So even when you go and bring a bank statement to say, look, on the 1st of June, this is how much I gave to this one. I say, no, leave that, your statement of account. I don't want to. Why didn't you give her this one, this particular? So that is how you. I don't know what my learned friend has to add.
But let me add a practical observance, because in the course of practice, I witnessed one of such situations whereby when we go to court, there's this particular judge that has been in that community and has been, in short, he knows all the lawyers there. Now, we were having a matter before this judge. So, but we observed that whenever this one particular lawyer is a very senior lawyer there, once he comes to court, any motion that he moved, any application that he applied for, the judge must give him. You understand? Because, in short, maybe they are very close somehow. So each time, until one day, one of our senior lawyers from the same chambers we work together, now had to ask in court, why is it that whenever this young man, this lawyer says anything, sir, my lord, you always nod and give him. And is it that nobody can oppose him? So the man became angry. So because of that, when it got to our own turn, there was an application we filed. So from the look and the body language, and everything shows that we are not going to succeed in that application. So that is bias.
That is bias.
Once you see like that, you know that something will be wrong. Yes. If you are a wise lawyer, the best thing to do is to apply for transfer of that matter to another court.
Okay.
Yeah, so that he will not jeopardize the entire
So,
proceedings.
so we are talking about partiality, we are talking about partisanship, we are talking about favoritism, we are talking about unfairness, we are talking about one-sidedness, we are talking about bigotry, predisposition, racialism, racism, sexism, heterosexism. There are a lot of things. Intolerance, that like what we just talked about, Deborah.
Yes.
Deborah. Now it's just a case of intolerance. He shouldn't have. Why should he have? There is nothing the person has to say. Kill him. You understand? So intolerance, all that are elements of bias in a case. Determination, propensity. You understand? So once the person is that this is unheard of. You remember what happened to Gideon in the Bible when he broke the Baal, just like what Deborah Samuel did.
Yes,
and something happened. I think he answered and said, let Baal speak for himself. That you do not have the right to come and speak on behalf of a God. That the God is let that God. If I break God, let that God come and talk. But this was God of stone, now ordinary wooden stone. So that God could not speak. So sometimes it looks as if the God they are protecting cannot talk, because if it's a God that can talk, he could have maybe strike down Deborah somewhere then before them even get to her.
Exactly.
Yeah, so that all those are elements of bias. And then when it comes to into judicial, judicial matters, when it comes to adjudication, it will become very obvious. In fact, if you listen to the comments that were made on the death of that young girl, you realize that none of them said anything different from that she shouldn't have lived. So that is already biased. Meanwhile, they did not hear her saying those defamatory and blasphemous statements. They didn't hear her. It was only the classmates that said they heard, which is already hearsay under our law, which is inadmissible. You understand? That was on its own inadmissible. But because they are already biased, they are already preconceived, they are already bent, they are already inclined, there is already that bigotry, there is already that favoritism, that is not a Muslim, is a Christian. So that, if you look at the totality of that case, you can really explain what bias is all about.
Thank you very much. Yes, when we're talking about the judge and noticing the action or whatever it is that the judge will do to cut or to bring out that this judge is biased. Now, when that kind of situation is being captured, who in this court now can have the right to stand up to the judge and say, sir, you're being biased, or Mr. Judge, sir, or ma, this thing you're doing is being biased, and what is the punishment to be given to this judge if he's been found in that aspect?
Well, if in that case where there is element of bias, I think counsel had already answered that it is the lawyer to the litigant. It is the lawyer to the litigant that has the power to say that they are not favorable. My lord, we are not favored in this court. We want the matter transferred.
So it can only be transferred.
The matter,
nothing else can be done.
The matter can be transferred. Like in Nigeria, we have the National Judicial Council. A petition could be written to the National Judicial Council, and the judge can be penalized. Then the matter can be transferred. That is the ready remedy.
Easiest remedy.
The ready remedy is for to transfer the matter. Then if it goes on appeal, another remedy you can take is for you to go on appeal. You appeal on that subject, on that issue of breach of natural justice. And then the Court of Appeal can order a retrial before another judge. In this case, now if you go to Court of Appeal Calabar now, the matter was Cross River State High Court. When the Court of Appeal say retry, they won't send it back to Barrister Osim, who was the judge in that case. They may now send it to me for a retrial, and then I ensure that I now give a ruling, which still goes back to NJC to see the difference between what Justice Osim did and what I did. So that is how they die. So it is the lawyer that will have to observe that, look, there is breach of fair hearing against his client, and then takes it up through one of those measures, either to apply for a transfer or to go on appeal on that issue. Then take a stay of proceedings, go on appeal, and then when the ruling is delivered, if it doesn't conform with, you can still go to the Supreme Court. But along the line, one of the courts will definitely do justice to the person that was.
So it can be transferred to different courts as many as
possible
possible
until the justice is done. In
okay,
the case.
so in a situation whereby I am a lawyer and I have a client, and I'm bringing my client to this particular court, and I know very well that my client is guilty of a particular crime,
okay.
And then coming to this court, the maybe the judge rule against me, or maybe the judgment does not favor me,
yes,
knowing very well that my client is guilty, but because I determined to say that this person,
okay.
I must win this case for this person.
Okay.
Now, in that kind of a situation, can I transfer my issue to another court, being that I felt that the judge did not give me the justice I wanted because I determined I want to win that case for my client? I don't know if you understand my question.
Yes, we understand you perfectly.
In that situation, you don't transfer. What you do, because already from your story you said, I know that
yes,
my client is guilty.
We don't come out to tell people that my client is guilty. I understand we lawyers, we know that.
I know, you said, I know that my client is guilty. And then I still went with the matter to a particular court. And then that court now gave judgment, is it not? Then, which was against my client.
Yes.
Then, in that case, you don't transfer.
You don't transfer.
What you do, you appeal. If
yes.
you feel, you still
yes,
have
you
the
appeal.
chances.
Yes.
Okay.
Because you may not know that your client may be guilty, but because of technicalities,
one technicality or the other,
as you
yes.
go on,
yes.
he wins.
Yes.
You understand? So you continue moving from one higher court to the other until you get to Supreme Court. When one Supreme Court gives his ruling, that is
you then appeal to God. One thing I have to add there is that it is not the duty of the lawyer to abandon a case simply because there is enough evidence to show that the client is guilty. Okay. It is not our pride. We are ministers in the Temple of Justice. So the Temple of Justice shows that there was adjudication. Justice must not only be done, but must be seen to have been done.
Yes.
Now it involves all the parties, all the operators of that system. You understand? So the lawyer is involved, the judge is involved, the criminal is involved, the accuser is involved, the parties that come to testify, they are all involved. So at the end of the day, like we said on the last episode in this program, that let the common man who is observing proceedings in that case come out with the view that this judgment that has been delivered is correct. And that is why, like in some jurisdictions, like in the American jurisdiction, we said last time that there is always a jury, the judge and the jury. The judge delivers judgment based on what the jury. That is the common. They can just go to the street, pick people, and then they'll come and say, "Come and listen to this case." So at the end of the
jury are from the masses.
Yeah, the masses, the people. So at the end of the day, each of them will write what they feel about that case and hand it over to the judge. And based on that, when there is more number of people that say yes, the judge will now deliver judgment in favor. If there are more number of people that say no, the judge will now deliver judgment against. But let the common people be the people that will be the judge of it.
Be the judge. So do you feel that these juries cannot be bribed?
In most cases, they are not, because there are people that are not aware. There are people that are just called upon. They don't know you. They are just called upon. Okay, for instance, in Nigeria now, they can pick somebody from Sokoto to come and be a jury in Akwa Ibom. If the black man is coming, what is he coming for? When the government has fully paid for his accommodation and paid, yes. So what is it? Just sit down, listen to the case, and then give your own view.
Okay.
Yes.
All right. Thank you very much. Beloved, I'm sure you are enjoying this, and I'm sure you're learning as well. Don't forget, our lines are open if you want to call us in for any question at all. Feel free to do so. If you don't want to call in, you can as well send your message via our YouTube platform, and I'll read it out here for the legal practitioners to give justice to your question. So now I would like to proceed to the provision of the law that ensures natural justice. what are the provisions of the law? Can you mention the provisions of the law that ensures natural justice in our courts today?
Well, they are mostly under Section 36.
Okay.
Section 36 of the 1999 Constitution. In fact, that is the most important aspect of natural justice. That is those provisions in Section 36 of the 1999 Constitution that are very, very important. The first important one is that the person is presumed innocent until he is proven guilty. The second other one is that the person must be given notice of the offense he has committed, no information on crime. He must be given that information that this is what you have done, and then be given an opportunity to come and defend himself. Then another one is that a person that is tried of a criminal offense will not be forced to give evidence at his trial. As in, if the person has been informed about the crime, and then a date has been set, he has come to the court, they will not like force him, like what happened in the Bible where they were asking Jesus, "Answerest thou nothing?" But in this case, the person will not be forced to give evidence at his trial. That is another one. There is another one that the provision still under that Section 36 that says that there must be a written law that the person has committed the offense on. What we are now trying to say is that it's not at the whim and caprices of the judge or the government. That law must have existed. For instance, under Section 38 of the Criminal Code, I'm just giving an example. Thou shalt not kill. That law has existed. So if somebody now kills, you understand that the person is now tried under. But it wouldn't be after the person has killed. They will now look for a law to punish him. The law leans against that. There are a lot of other rules of natural. Let me give my brother the opportunity.
On my part, I will say that we have many rules or many laws in Nigeria that has the element of natural justice. For instance, like the Constitution, which my senior colleague is talking about, we have chapter 4 of it, which talks about fundamental right. So in that fundamental right, you have section 33, sub 1, or let me say the whole of section 33 talks about right to life. Then we have section 34, which talks about right to liberty. We have dignity, sorry.
Human dignity.
Human dignity. Yes. We have section 35, which talks about life to liberty. We have section 36, which talks about fair hearing.
Fair hearing, yes.
Then section 37 talks about private life and family life. So, and so forth. So now all this talks about, they are, those provisions are for natural justice. Yes. If you breach them, then the law will come against you. And also we equally have other laws, like the law of contract. Sorry, let me start from criminal code. Criminal Code Act or Code Law, which talks about, which frowns at murder, manslaughter, forgery, stealing, all that. That is bad because it's against natural justice. Then equally we talk about a law of contract, which says we should keep to our promises. We should be like God by keeping to our promises and agreement. When you have contract with the other party, the expectation is that both parties should keep to the agreement. Then that is natural justice. Then also we talk about money laundering prohibition act, which talks about, which is against embezzlement of money. You hear EFCC this and that, because it frowns against it. Then we also talk about law of tort. In law of tort, that talks, there's a principle we call the neighbor principle.
Neighborhood principle.
Yes, this neighborhood principle was founded in a case called, in the case of Donoyo versus Stevenson,
Okay.
whereby that quotation in the Bible, Matthew chapter 19 verse 19, which says, love your neighbor as you love yourself. Now in law of thought it is, do not injure your neighbor. That's the neighbor principle.
Wow.
Then we also look at law of trust. This law of trust tells us that we should take care of the widows and the fatherless. That's to say, when when a man dies, leaving the wife and children, law of trust comes in. You know, the estate and all that. So when you now look at all these laws, you see that they all have the element or ingredient of natural justice. So, which means we have to abide by them and keep to them in whatsoever we do, so that we will not breach that law of natural justice.
But for me, I'm looking at the situation where he has breached.
Okay.
He is looking at it, don't breach.
Don't
But
breach.
me, I say it has been breached.
Okay.
And now this man is standing before a court. And first, like I was trying to explain, you have to inform him in the language he understands.
Yeah.
And in detail of the nature of the offense he has committed, in the language he understands. Mark my words.
Yes.
In the language he understands. So that
understands.
if the man does not understand English, you do not inform him in English. If you inform in English, the law expects you to do something else. Then, given adequate time and facility to prepare for his defense. And that in case he's not understanding the language, he is entitled to defend in person or by a legal practitioner. In person, he can defend himself, or he should defend by a legal practitioner. And that legal practitioner should be of his own choice, such that the man can stay here and get a lawyer in Sokoto. You understand? He can get a lawyer from, provided those people are within the jurisdiction
where he can reach them.
Where he can reach them. Then he should have the right to cross-examine, to examine and cross-examine and re-examine, either by himself or a legal practitioner, the witnesses called, so that all the people that call and say, I saw him killing that man, all of them will be examined, cross-examined and re-examined. That is what the law says. So that at the end of the day, the totality of this examination will bring out the truth. The greatest weapon of a lawyer or a legal practitioner is cross-examination.
Yeah.
By the time a person is put under cross-examination, no matter how difficult it was thought to be, that person, the defense of that person will fall like a pack of cards.
Wow.
If the lawyer knows what he's doing, the legal practitioner knows what he's doing. So another thing is that the person that is tried for a criminal offense must have the assistance of an interpreter, or say in case he is not
Understanding
the language, where he doesn't understand the language used at the trial, he must be given free of charge an interpreter. Then another aspect of it is that the person that is tried for a criminal offense shall keep record of the proceedings. There must be record of the proceedings, because things normally happen. For instance, a man was discharged and then the story goes out there that he was convicted. So, but it is the record of the proceedings that will go to tell the truth, whether he was convicted or he was discharged. Then another thing is that the person shall be held, no person shall be held guilty of when...
Okay, let's take this call, our first caller for today. Hello.
Hello, peace to the Father.
Peace of the Father. Good evening.
Regnum.
Yes. Thanks for calling in. What's your name and where are you calling us from?
Okay, this is Sister Correct. I hope it's the same program I'm looking at it on. I have a question.
Okay.
Can you hear me?
Yes, we can hear you. Go
My
ahead.
question is, in Nigerian law, of course, do they have what you call it, litigation for oral agreement between two persons? You know, so let's say you and I have an agreement, a contract, but it's verbal. Do they have such laws surrounding that and applicable to such situation in Nigeria? That's my question. And two, if the other lawyers besides justice, besides by here, I'm not. Thank you.
Sorry, come
I
again.
didn't
Your
hear the second
second question.
question.
Yeah, your second question, please.
No, I just want to know if the other person is a BCS member.
Yes, yes, they are.
Oh, thank you very much.
Okay. All right. You get her question.
Yeah. Her question is whether oral
oral
agreement,
agreement.
that is
Yes.
what we call it, oral agreements can be the subject of litigation.
Yes.
That is what I understand that to mean. Yes, if there are first standard form agreements
Okay.
are normally written, but if there were no standard form agreements, when there were no written documents, but there were oral agreements which
known as parole.
yes, if there are oral agreements that can be testified on at the trial, one, and then there are customs and usages concerning that line of agreement. There are customs and usages. For instance, if you are taking a bus from Wat Market to what's the name of that, 8 miles.
8 miles.
If they used to pay 100 naira, sometimes it may not be written down that you pay 100
You have to
naira.
pay 100, yes.
You understand?
Yes.
So it might have been oral, but if the boss man now says 150 instead of 100 naira, that extra 50 is the doubt that is created, because everybody knows that from Wat Market to 8 miles is 100 naira. Now it is the word of the claimant and the word of the defendant that will now be used in settling that matter. So by the time she was entering this bus, I said it's 150. You understand? We had increased our fare to 150. So if at the end of it there is an extra witness to point to the fact that yes, I actually heard this man telling him or her that it is 150. So it is true. Oral agreements are binding. Oral agreements are binding once there can be evidence pointing to the fact that there was such an agreement.
Yes. And their witnesses to testify.
And there are witnesses to testify.
The
Yes,
situation where the driver did not inform the passenger before entering, what happens?
Then that is the turning point.
Okay.
That is
So that customer has the right not to pay that
not
money.
to pay that money and then
Above.
revert to the custom.
Not to pay above
the custom.
Cost, yes.
Yes.
Okay. All right. Thank you very much, Sister Karen. I'm sure you've been cleared with
Oral
this.
agreements are actionable.
Yes.
That is my answer to you.
Okay, thank you very much, Barrister. Yes, now I would like us to take our last question, which is, what are the exceptions to the applicability of the rule of natural justice? The exceptions.
Yeah, there are several.
Barrister, yeah?
Okay.
Barrister, see?
The
Why you-
exceptions to rules of natural justice. One of it is necessity, a doctrine of necessity and absolute necessity.
Okay.
Now, let me explain a little. The doctrine of necessity is that when it is necessary that such a decision should be taken. For instance, now, you have a case at hand, and the only person there who is to be the judge or the arbitrator of that matter is a biased person, that's to say has interest in the matter. Now there is no any other person who is to sit on that matter. So it's necessary that he takes over, because a decision must be reached.
Must be reached.
Yes.
Okay, let's take this call again. I think it's same caller. Hello?
Hello, Sister Father. Yes, me again, Sister Corinne.
Okay, so Karen,
I
thanks for
have
calling
another
back.
question.
Okay.
My question is this. Suppose you purchase land or property there by proxy. When I say proxy, that you use a representative.
Yes.
And on getting there, you realize that the representative actually claims everything as a whole. Take a raw personal thing.
Yes.
Whereas you, the person was supposed to, he or she's supposed to be representing you. How does one address that legally there? In the name of Allah, what is the legal advantage we have in retaining or, being able to tell my system, being able to regain the property which I didn't entrust in it, but the representing me and purchasing it, and it should have been in my name, right? And because of all this language barrier and whatever, hope that somebody who doesn't know the language address this property effectively, because the purchaser and the buyer.
Okay.
In the name of God, the Lord.
Amen.
Amen.
Okay, let me answer that question.
Okay.
Let me
Yes.
have so I can listen to you.
Okay.
Now you have a representative. Let me say in a legal term, we can say an attorney. That's your attorney that you have given or donated a power of attorney to, or you have mandated to carry out a function for you since you are not there. Now this person has all the right and obligation.
This person only is proxy by, when they say proxy, by proxy, so-called proxy. Not in a situation where this person is an attorney. Because when it's an attorney, that means it's a titled and non-representative. It's a documented representative.
Yes.
But in a situation where we are brothers and sisters. And I now say, oh, I am not in Nigeria. Please go and buy me land. And then you go to buy the land on my behalf. It is my land. I am the one that gave you money. And then at the end of the day, what you now do is that when you bought the land, you put your name on it.
Yeah.
You put Roland Osim as the purchaser, and then put your name as the vendor. That is what the angle I want to go.
Yeah.
He has gotten it right on the angle of when it is documented. Now it is my word against his word that property. Remember that all the evidence we have is the money sent to my account.
Yes.
There is no evidence that he told me to buy any land for him. That money could have been used for any other purpose.
Yes.
So that is what I'm looking at, that the sister may have been asking.
Yeah.
Now in that kind of situation, how do you make it known that that house or that motor that that man is driving is not his own, but rather that it is that of that sister that sent the money, or they had an arrangement between both parties? Well, my own answer is what Barrister Roland Osim said earlier. Is only that he already assumed that there is a power of attorney. What what my answer will be is that let anybody that wants to act by proxy, let it be documented that the person is acting by proxy.
Okay.
And the only way for it to be documented is for the person to be appointed as an attorney in a document duly signed between the parties. If there were going to be monies to be paid, how much was to be paid? If there was an action to be taken with the money, what action was to be taken? If there was going to be a percentage or payment or commission, what percentage of that money is a commission? So that both parties put on to paper before a legal practitioner or a witness that this is what was agreed upon. So that that proxy, so-called, becomes an attorney, just like the counselor said. Apart from that, it is his word against her word. And then when the person does not have conscience, when the person is ready to die, even if the poor libation for him is ready to die, then it might be difficult to trace out and find out. And in fact, what that question that sister is asking, I've seen it. There was a place I was living, and that was the problem. The brother was in London, sent a lot of money to his younger brother to build an upstairs. After building the upstairs, he now informed the wife and children that that house belongs to him. And not long after he did that, he died. And then the elder brother, who was an accountant in London, came back to come and take the property, only for the children of this to get up and say, it's our father's house. There was no documentation. There was no witnesses. It is your word against my word.
Okay.
So in that kind of circumstance, like what happened there, they resorted to self-help. And the self-help, you know what I mean by self-help, juju?
Wow.
And the thing ended up almost finishing the family of the man that had died, that said it was his property, because you know that thing now somehow will be looking for the truth.
Yes.
So by the time they go, the thing will start. It made one of them mad. I actually saw the one that got mad when he now claimed it's my father's car. That is how the guy fell down there and started talking out of point. So please, in order to avoid such a situation, so that you do not offend the law of God that says thou shalt not kill, thou shalt not hurt your neighbor, please have it documented.
Okay.
whatever was to be done, whatever was to be action that was to be taken, call one person to be a witness. Let them write something. Let somebody sign something. You understand?
Yeah.
If at all you are not around, you can send that document to somebody who is in Nigeria or who is in Calabar. Let that person take it to the person you want to take the action. Let both of them sign and then snap it on their phone and send it back to you. So that you see that Mr. A has signed, Mr. B has signed. You keep that document.
Okay.
So that tomorrow you say, Mr. A was even my agent that went to him to broker this deal.
Okay.
Because it might become very difficult.
Okay.
And those people that do not listen to the gospel and practice it may take advantage of such situation.
Okay. Thank you very much. I actually wanted to ask a situation whereby I'm not in this country and the person is in the other country,
Yes.
but you've made justice to that question already.
Yes.
Thank you so much. Mr. Karen, I believe you've been cleared, and if you still have other questions, you can as well call in, and other people too that want to be cleared about a particular issue. We are talking about the applicability of natural justice. Feel free to call us in and as well ask your question via our YouTube. Sister Gladys, I can see you, and of course I'm going to take your question just immediately after we finish talking about the exceptions. You know, I think you were talking about the exceptions.
Yes.
Yeah.
Then second, we have situation of emergency,
Okay.
where there is no time. There's an emergency. You have to forgo the strict
Yes,
compliance
application
with
the rules of natural justice.
natural justice. For instance, now, in a particular Indian case of Mosing Jill versus chairman of electoral commission, you know, there was a particular election going on in a constituent. Now, it was seen that some mobs came in and then carried the ballot box and then disrupt the election. Then at the end of the day, the chairman of the electoral commission cancelled the election and then gave notice for a fresh election to be conducted. So the other aggrieved parties, and they went to court. Then the court said, yes, it is necessary that the action of the chairman of electoral commission is necessary because there was a situation of emergency. So that is one. Then we equally have a situation where the public interest, you know, is affected. Yes.
Yeah.
So when it is now, like when I talk about section 33 sub 1, which talks about right to life, you know, it is that you should not take away someone's life. But now, in a situation where you are an armed robber, and then you stole, and then you were now arraigned in court, and then convicted and sentenced to death, you cannot be hard crying that your right of fair hearing has been breached. So those are the situations. And also, it can equally be used as an academic exercise, evaluation. They may be using it maybe in lecturing you, then they can breach those exceptions. Yes. So
and then it might be impracticable.
Yes.
It might be impracticable.
Impracticable also,
yes,
because you need to, fair hearing should be done where it is practicable. When it is impracticable, you cannot do otherwise. For instance, now there's a particular case which I cannot remember the parties. In this case, an examination council, they set exams for students, a group of students, and then they found out that they were copying each other's. So when the information was given, they came and verified that it is true. The examination board now canceled the exams and then set a fresh examination for the students. So these students were aggrieved and went to court. And then when they went to court, the High Court gave judgment in their favor that they are being denied of fair hearing. They were supposed to give them fair hearing. So the Supreme Court now said no, that the action of the examination board is right because it will be impracticable for them to listen to all the students at that short
Okay, sorry, let's take, we've lost it. Please, You can call us back. Okay, sorry, we've lost that. Continue.
Okay, so those are the
The applicable Latinic maxim is let's not cogit ad impossibile.
Okay.
The law does not compel the doing of an impossible thing. Just like he has explained, that within that short period that all those students could not, because each of them will have a different scenario, a different situation to explain. So under that kind of situation, the let's not cogit ad impossibile will apply. So those are the exceptions, like he has listed. Those are the exceptions to the rule in cases of emergency, in cases of necessity, when the constitutional provisions does not allow, like he's talking about. Okay, go on.
Let's take this call.
Yes.
Sorry, before we visit again. Hello, good evening. Hello. Hello, good evening.
Hello?
Hello, good evening.
Hello?
Good evening, we can hear you. What's your name and where are you calling us from?
Okay. Thank you. This is the first again. One last question.
Yeah.
Hope our lawyers have working corporate lawyer, corporate law, deal, or business law, whichever one you call it. I have a question. What if a non-Nigerian has... Hello?
Yes, we can hear you.
Hello?
Yes, we can hear you. Go ahead.
Okay. What if a non-Nigerian has is a client of a business, let's say a bank, and you need to have your DVN, but because you're not, what does the person do? What should the person do who has an account there and needs to acquire the DVN so they can do their own transaction and so forth from overseas, but it's not a native of
Okay.
Nigeria?
Okay. Did you get that question?
Understand.
Yes, if I understand you correctly, what a situation where somebody that is not a Nigerian has an issue that has to do with bank and this BVN is required in that kind of situation, what should the person do? Right, Sister Corinne?
Yeah, I'm making it.
Hello? Yes, I think she made mention of BVN and a bank and a situation whereby she is not a Nigerian and maybe there's a transaction that needs to be done and then maybe a BVN pin is requested for that transaction. What do you do in that kind of a case since we are having issues of signing and documents and paper?
Well, I don't normally want to come on set and say what I am not so sure of.
Okay.
But I know that if a person is a non-Nigerian and that person is not in Nigeria, because if the person comes into Nigeria, then it means that the person
will
definitely have those things. Yes, will have those things. But let's assume that the person is not in Nigeria and the person is doing transaction with a Nigerian bank. I think that will be done through a domiciliary account.
Okay.
Which have relationship between the bank in Nigeria and her own bank in her own country.
Okay.
So in that kind of situation, I don't think that there will be much of emphasis on BVN number.
Okay.
But unless if the person was in Nigeria, was part of Nigeria and was known, you know, somebody can be a citizen by birth, by registration.
Yes.
If the person, then all the person needs to do is to come down to Nigeria and perfect. You know, the Latinic maxim there is that consented must not complain. If you agree to be a Nigerian, then all the wahala of Nigeria, you have to face them. So the person have to come to Nigeria. But if the person is actually a non-Nigerian living abroad, and then there is a transaction in a bank, I think there is what we call a domiciliary account, where there will be a clearing when it gets to a clearing house between the Nigerian bank and her own bank in her own country, where those funds will be paid. And in case those funds are not paid, then she has a problem to go to her bank and lay a complaint that such money was to be paid from First Bank or GT Bank or Citizen Bank or whatever bank. And then it is the duty of that bank to interface with the Nigerian bank and get that money.
Okay.
And that is why we have clearing houses.
Okay.
bankers, clearing houses. Yes.
All right, thank you very much.
Yes.
Yeah, before we draw to the conclusion part of this topic we're discussing, let's go to a question coming from Gladys. So, Yebo, Sister Gladys. It says, special greetings to our guest speakers. Well done, a beautiful presenter. Please, what about a situation where natural justice is ignored and injustice melted out on the innocent? What is the way out of it? Should I take the question again?
No, we understand you. It's just that I was
Okay.
expecting Marisa Osim to answer that question.
Okay.
Okay, please repeat.
Okay,
Let
the
me
question
get to it.
says, what about a situation where natural justice is ignored and injustice melted out on the innocent? Injustice is being served on the innocent and the natural justice has been ignored. What is the way out of this kind of situation?
Yes, like if she was following us from beginning, yes, that was where we talk about the remedies.
Yes.
The remedies, yes.
Where we have nullification of the entire
That
process.
yes.
Then we also talk about damages
Retrial.
and compensation. We equally talk of retrial, and we talk of appeal, and then apology.
Yes.
So any of these
Could
can
apply to that
Can
situation.
apply to that
Yes,
situation.
yes.
Okay. Thank you very much, Sister Gladys. I'm sure you've been cleared with that. But just in case you're not clear, you can as well go back to the program again just after we conclude and rewatch from the beginning so you can get those facts right, so you know your rights wherever and whenever you want to make use of them. All right, so without drawing or wasting much of your time, I think we've concluded on this whole topic, the applicability of natural justice in the judicial process, and we are going to go to a conclusion, which I will take one after the other, your conclusion and your agreement to whatever that has been discussed for the past 3 weeks on this particular topic, being that is very, very broad. And I want to thank our constant audience that we're staying on to this program. I'm sure you've been able to understand your natural justice and how to make use of them. We'll be coming up with another topic, another powerful one, so stay glued to Regnum. But before that, let's go to our conclusion for the day.
Well, my own conclusion, my own parting words to this topic is a Latinic maxim.
Please break that down.
Justitian non est neganda,
Okay.
non deferenda.
That's Latin.
Justitian non est neganda, non deferenda, which simply means just to no one should justice be delayed
Delayed.
or denied.
Denied. Okay.
Yes.
Please teach me the word again. Just what?
Justitian non est
Justitian.
neganda,
I
non
don't want to
deferenda.
cut my tongue. Okay, thank you.
So to everybody,
Yeah.
justice is a natural, is nature. Natural justice is nature. And so to nobody should it be denied. Everybody, even God, when he began creation, when he created Adam and they fell in the garden, he didn't deny them natural justice.
Yeah,
He still made
called
clothes
them
for them, gave them clothes. He gave them the punishment actually, but you realize that he still gave them clothes, he still allowed them to live. He still didn't give them torture, he didn't treat them like slaves. You know, he only asked them the question and they were the ones that supplied the answer. And based on that answer, he gave them the punishment. And even that punishment, God since then had worked to ensure that he lifted that punishment.
Yeah.
And the lifting of that punishment was Jesus Christ, who came and died on the cross of Calvary for our sins. You remember?
Like
and
that.
by dying on the cross of Calvary, you remember when we were talking about, you know, standing mute. You know, the devil stood mute when God was asking him, why have you done this? He didn't answer. Before God meted that punishment, he told him that he was going to bring out a seed, that the seed of the woman would bruise his head. And since then, you realize that immediately trouble started in the world. Cain had to kill Abel because they were thinking Abel was the seed. But God, who is wise, the all-wise, the all-knowing God, the omnipotent, the omnipresent, knew that Abel was not the seed that would bruise the head of the serpent, but that Jesus Christ himself will be the seed that will bruise. And that was why immediately Jesus Christ came and started his work, the devil had to tempt him after. Remember, it was after God said, this is my beloved son in whom I am well pleased.
Yes.
He's now saying, so this is the seed that was to come and bruise my head. And so he started tempting him. But then Jesus Christ overcome them all. And even when he was standing before Pontius Pilate, when they said, answerest thou nothing? He said, after now you see me sitting at the right hand of power. So Jesus took dominion. Man could not take dominion. Adam said it was Eve. Eve said it was the serpent. But when Jesus Christ came, everything that was said, he said he would do this. He said he took all those. And at the end of the day, he said it is finished. And everything, all our sorrow, all our problems, all our injustices were finished on that cross of Calvary. And after that, all of us became freeborns. And that is why we can cry, Abba, Father, that we ourselves are the children of God, who is Jesus' Father, Jesus Christ's Father. You understand? So that is the summary from me, that the rules of natural justice, they are the rules of God himself.
Okay. Thank you very much, Barrister Kenneth. Yes. Barrister Sim.
Thank you. My last word to the audience is the two Latin maxims, which are Nemo Judaeus in casu sua and Audi alterum patem. That is to say, in all our proceedings, these two principles should always be there. Once they are there, then it will be devoid of breach of fair hearing. Now, the interpretation is that Nemo Judaeus in casu sua, that is to say, no one should be a judge in his own case. Then the other one, Audi alterum patem, that is to say, give the other party a listening ear. So once that is done, that is the end of justice.
Thank you very much. Let me applaud my legal practitioners, because they have really done justice to this particular topic of discourse. And I also want to appreciate you, beloved audience, for staying glued to your TV screen. And I appreciate all those caller for today. Sister Curry, thank you so much for calling in today. And Sister Gladys, thank you so much as well for your comment and your question. Thanks for your contribution. I really appreciate all our audience that we're watching online on TV but could not call in. Please, next time, stay glued, because we have another interesting topic that we'll be talking about very soon. So stay glued to StarCrest TV and enjoy the rest of the programs that will be coming your way immediately after now. My name is Joy Dambo, and of course, before I go, let me reintroduce, of course, our barristers here again. Christ Ambassador Barrister Kenneth Itoro Abasi, and Christ Ambassador Roland Osim, Barrister. Thank you so much. Thank you all for coming.
Thank you.
Remain blessed and enjoy the rest of your nights. For those of you in America, remain blessed and enjoy the rest of your day. Thank you so much. Bye for now.